I still don't know who it is.
Hello. Deputy Phillips, are we ready to begin? You're on mute. I don't read lips very well. Or at all.
There we go. How about now, Judge?
Much better.
We've got Mr. Knoll here, sir.
All right. Good afternoon, Mr. Noel. How are you, sir?
Yes, pretty good.
Just pretty good.
Just pretty good.
Just pretty good. Hey, that's acceptable. Who do you want to go on first?
Mr. Moorhead, I think was set for arraignment when I was out with COVID, so I think we just need to kind of formalize that.
Okay. Come on up, Mr. Moorhead, CR 21180. Mr. Moorhead is set for arraignment on bail jumping, failure to appear. Have you had a chance to go over the indictment with your client?
Judge, I haven't seen an indictment on a bail jumping. Maybe that's just kind of sitting in the back. I don't know if that's been filed in, but as far as the aggravated robbery, we have reviewed the indictment. He understands what the charge is. His name is spelled correctly, and for the purposes of arraignment, we would enter a plea of not guilty. It's my understanding. Judge, he actually retained a lawyer who, I guess, fell by the wayside. He was then appointed a second lawyer. I think Dean White, who obviously is no longer with us. So I think I'm either I'm the fourth lawyer. There was another lawyer in there someplace along the way. This case has got a little bit of age on it. I think it's from 2017. I'm not sure. I haven't had a chance to look to make sure if the discovery has been made available to me, but I'm sure it will be. In fact, I'm not even sure if it's on the portal since it's that many years old. May be obtainable otherwise. My client says he's actually reviewed some, if not all, I don't know yet, of the discovery, but we'll try to see what we can do to move it along since it's a bit old.
Well, let me get caught up here because I'm not understanding what I have.
Can I straighten out the record? Would that be helpful?
Yeah, please, because what I have on the record is or what I have on the docket is bail jumping. So the other one to be resolved. Go ahead, Ms. Heisen.
Judge, Mr. Moorhead has the aggravated robbery that is, I believe, assigned to the county court at law. I know it was set for trial down there, and that's the that's how we got to the bail jumping. I believe it's assigned to that court that is a 2017 offense, 2018 cause number. But I believe all we're set on in your court today is the bail jumping that arose out of that case.
Are we gonna carry the cases separately, one here, one there, or and who represents Mr. Moorhead downstairs?
Judge, we show Kurt Knoll as the attorney of record on both. So I don't know what his appointment looks like, but we do show him on both.
Let me, the docket that I have is actually for the bail jumping. I didn't get a copy of the bail jumping because the appointment that I have says ag robbery. Let me make sure that. And then there's another appointment, looks like after the first one, that says ag robbery and also includes the bail jumping. And it would be nice to get them both in one court if that's possible.
Everything's possible with a motion, probably. Let's go ahead and arraign Mr. Moorhead today on the bail jumping, and then I'll let you and the state figure out where y'all want to put one or both.
Judge, I don't have a copy of the bail jumping because I thought I just had an ag robbery. Judge, we don't need to read it. I think I've seen a few bail jumping indictments before. I could explain the process. The only thing I can't see is the date. If we could slide it to one direction or another. How that works. Okay, May 24th of 2021, I think I see.
Come on. You see a date?
Yeah, I saw it. It's that on or about May 24th, 2021. Okay, Judge, now I can't, if I could just see his name, I'm sure it's spelled correctly.
Are you not seeing? I've got the whole document blown up on the screen. Are you not seeing that?
I see the body of the document. I can't see where his name is.
Tell me, since I'm not there and I can't see what
Okay.
you see, tell me what you want me to do.
Okay, let me just read it in the, or let him read it in the body of the indictment. I think we can figure it out. Is your name spelled correctly there? Correct. Top and take it. Yes. Judge, after reviewing the indictment, the defendant understands that apparently he's charged with failing to appear on May 24th of 2021. His name is spelled correctly in the indictment, and for the purposes of arraignment on the bail jumping case or failure to appear, we enter a plea of not guilty.
All right, the court will find Mr. Moorhead has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. We'll set this matter for pretrial. Do you know when your next setting in the county court of law is, Mr. Knoll?
Well, actually, it's Monday, but that's a little too soon.
It's Monday. It's Monday. Okay. All right. So what if we set you on this for August 23rd, and that gives you more than 30 days to figure out whether to move this one or move that one?
That sounds like a plan to me, Judge.
Are you available on that day, August 23rd?
Should be.
Okay. All right. We'll set Mr. Moorhead then for pretrial August 23rd at 1:30.
Thank
And
you, Judge.
Judge, to the best of my recollection, the reason that was moved downstairs is because you recused on it. And so I will double check and I'll shoot Mr. Knoll an email to confirm that. If that's the case, obviously he would want to transfer downstairs, not the other way.
Thank you, Ms. Sutton.
Thank you, Judge.
You're welcome. Mr. Knoll, do you have anyone else that's ready?
Actually, no one else is ready. If the court wants to go see with someone else, I'll let the court know when I've got.
Okay. Thank you, Mr. Knoll. We have any other counsel that's ready?
Mr. White, you ready?
Your Honor, I'm on Zoom and I'm ready, but I'm not sure about the defendant who is in custody.
And I'm sorry, I don't know who's talking. Who is that that's talking?
Your Honor, this is Michael Stevens for Shane Adobe.
Michael Stevens?
Yes, he may show Philip Linder as the attorney of record. I'm not sure if it's me or him, but she's in custody. I'm on online.
Okay, I don't think we knew that anyone was going to be appearing soon. Okay, yeah, we'll pull her up here in a moment and then we'll call her case.
Thanks, Your Honor.
You're welcome. Deputy Phillips, you said that Mr. White is ready?
Yes, sir. He's on his way over here right now.
Okay. All right, Mr. White, who do you want to go on first?
I've got Mr. Robertson. We're set to for a plea.
All right, CR 21-338, State versus Lance Allen Robertson. Mr. Robertson, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may lower your hand. All right, Mr. Robertson, a few questions for you. Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. White, do you believe Mr. Robertson to be competent today?
Your Honor, I believe Mr. Robertson is competent. I believe he understands the proceedings that are pending against him here today. Also believe that he waived his rights knowingly, intelligently, and voluntarily.
All right, thank you, Mr. White. I see here that Mr. Robertson was indicted with Health and Safety Code, first-degree felony, manufacture, delivery of a controlled substance, 4 grams to 200 grams. Appears that there were 2 enhancement paragraphs, and the state was seeking habitual felony offender 25 to life. Is it my understanding that the state's abandoning the enhancement paragraphs?
That's correct, Your Honor.
Okay. All right, Mr. Robertson, you are before this court on a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. A first-degree felony in the state of Texas carries a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice and an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
I see that the plea agreement is that you would plead guilty to that charge in exchange for the state's recommendation on a sentence of 12 years confinement in TDC plus a $3,500 fine, restitution, court costs, and reimbursement fees, with you receiving 149 days credit towards your sentence. Mr. Robertson, is that your understanding of the plea and what you're asking the court to approve?
Yes, sir.
All right. Mr. Robertson, then how do you plead to that first-degree felony offense?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir. I'm guilty of that crime.
All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
Your Honor, I have no objection.
All right. The court will admit the state's evidence, state's exhibit 1 stipulation of evidence. The court will take judicial notice of Mr. Robertson's judicial confession. And Mr. Robertson, I'm not sure if I've asked you or not, but Mr. White, being your attorney, are you pleased with his representation of you in this case?
Yes, sir. I am. Very much.
That's what I would expect you to say, but wasn't sure if I had asked you. All right, court's reviewing the evidence. I don't see what I have before me here. It doesn't have a lab report in there. Can someone tell me if there was a lab produced in this case?
Yes, Your Honor, there's a lab. They test the methamphetamine to 27.48 grams of meth.
Is that going to be included in stage 1?
It should be, Judge. I will email both Miss Patty and Mr. White so he can verify that that's what was revealed to him for everyone for inclusion. As we would offer that as State's Exhibit 2. I could share my screen if the court would prefer, or I could just email it if Mr. White has no objection.
I don't have any objection. I'll pull up mine real quick, Your Honor. But I believe that that's my recollection as to what the amount was.
If you want to show your screen, you can do so, Mr. Woodward.
Your Honor, we received discovery from the state, and it is 27.48. And we have executed our 3914 Morton disclosure, so we agree with the state on that.
Any objection to the lab being offered in State's Exhibit 2?
Oh, no, none.
Okay. State's Exhibit 2, as offered, is admitted. And the court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Robertson of this crime. The court will follow the plea agreement in this case. Court hereby convicts Lance Robertson of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. Court assesses his punishment in accordance with the plea agreement at 12 years confinement in the Texas Department of Criminal Justice, orders him to pay a $3,500 fine, $180 restitution, $290 court costs, and $85 reimbursement fees. Court awards Mr. Robertson 149 days credit towards his sentence for the time that he has spent in jail in this cause. Mr. Robertson, I'm going to have you accompany the deputy to be fingerprinted. Good luck to you, sir.
Thank you.
You ready on anyone else?
Justin Canyon, Your Honor.
Justin Lee Cannon, CR 21282.
Your Honor, we're set for docket call.
Step on up, Mr. Cannon.
We're set for docket call. Ms. Heisel and I had been going back and forth on this case and it kind of had a problem getting together to talk. The state yesterday, we were able to talk a little bit further. Ms. Heisel has extended 2 offers to us. Both would be pen time offers, Your Honor. One is on the current case that we got, and the other one would be on an unfiled case the state would have to refile. I'm back here on August the 11th. I'd ask the court to set that for final docket call on that day. We understand that that'll be the last time we got to make a decision that day.
Any objection from the state?
No, Your Honor.
All right, court will set Mr. Cannon for a final docket call on August 11th. That will be at 1:30. You ready on Mr. Cook?
Yes, sir, I am.
Dustin Lee Cook, CR 21162.
Your Honor, I'm going to ask the court to move this case over to docket call. Now, as I addressed the court earlier this morning off the record on this, there are a number, we've got some unfiled cases that Mr. Woodwhack is trying to get and kind of determine what we have. I will note to the court, I have not been retained on those cases yet. And I don't know if Mr. Cook intends on doing so. However, I know that they would be, fair game and punishment if we got to the situation on this current case. But I don't have anything as far as pretrial goes. Ask the court to move it over to the docket call, and we'll abide by the court's standing discovery order and pretrial motions order.
All right, there being no contested pretrial motions, the court will move this to docket call. Do you want that on that same August 11th date, Mr. White?
Yes, sir.
All right, court sets Mr. Cook for August 11th at 1:30.
Have you call.
Mr. Manning, you ready?
All right, Mr. Manning, who are you ready on?
Judge, we're here with Mr. Eric Hoover.
All right, Eric Ashley Hoover, CR 2268.
Judge, we were originally set for a plea today. However, Mr. Hoover has some additional charges I've just recently been appointed on. We'd request that we reset this case for pretrial as we continue negotiations with the state.
Have we already passed pretrial in this case, though?
No, Judge, I believe I was appointed in court last time. I spoke to the state. I think we waived arraignment at that point in time, and we were going straight to a plea. We'd asked that now we've taken off that plea docket and put on pretrial, so I can look at the discovery, go over that with my client.
So we weren't aware of these cases when we set this for a plea?
My understanding was he got arrested since we last had court.
So the last time he appeared in court, he was arrested?
That's correct, Judge.
All right, what date do you want, Mr. Manning?
Judge, if we can have the August 11th date.
All right, the court will set Mr. Hoover then for pretrial on August 11th at 1:30. Do you have anyone else that you're ready on, Mr. Manning?
Yes, Judge. Mr. Lyons,
Takiti and Lyons, CR 22-152. Mr. Lyons is set for pretrial.
yes, Judge. I came to visit Mr. Lyons on Friday, and he was in a restricted unit due to exposure to COVID. I've rescheduled him to go over his discovery this Friday and asked that he reset to the August 11th date.
Is it just so that he can review discovery or so that he can help you determine if there's going to be contested legal motions regarding suppression, or do you need him for that?
Judge, my client has expressed that he would like to go over discovery. There are some issues that he would like to discuss that may be contested. So yes, that's for the contested as well as to go to discovery.
All right, court will set Mr. Lyons for pretrial on August 11th at 1:30. Who do you like next?
Judge, looks like we just have one more. Mr. Couch.
Joseph Ryan Couch, CR 2153. Set on motion to revoke.
Yes, Judge. This is our first setting. I was able to visit Mr. Couch last Friday, but I've been in trial all this week, and so I've been unable to discuss what I talked to Mr. Couch about with the state in regards to seeking some sort of resolution. At this time, I don't show that I've received an offer to resolve his case, and so I'd request that we reset to the contested date with the understanding that at this time we've not entered into negotiations on his case.
All right, court will set Mr. Couch for contested hearing on August 25th.
Sorry, August what?
August 25th at 1:30. Who do you have next? Mr. Moore, Terrace Moore,
Yes.
Terrace Moore, CR 18407. Mr. Moore is also set on motion to revoke.
Yes, Judge, same announcement as Mr. Couch. I was able to speak to Mr. Moore and discuss his case on Friday, but like I said, I've been in trial this week. And so we request that we be reset to the contested docket. And if I get something resolved sooner than that with the state, then we will get him set for an earlier docket.
All right, Mr. Moore will be set for contested hearing on August 25th at 1:30. Mitchell, are you ready on Mitchell Ragland?
Yes, Judge.
Mitchell Ragland, CR 21-185. Mr. Ragland also said a motion to revoke.
Correct, Judge. Same announcement as the previous two. I did visit with Mr. Ragland, and I have some information to provide to the state in the hopes of getting him reinstated. However, at this point in time, I haven't been able to do so, and so I'd be requesting he be set on a contested for 8/25.
All right, court sets Mr. Ragland for contested hearing on August 25th at 1:30. All right, do we have anyone else that's ready? Is that all you have, Mr. Manning?
I believe it is at this time, Judge. Thank you.
Mr. Noel, you ready on someone?
Mr. Ibarra, Arthur Ibarra.
Arthur Ibarra.
Because he was another one that was supposed to have been here on the 5th when I was out with COVID. The last time we were here, I did not have the lab reports. I have since then obtained the lab reports, and you've had a chance to look at those. To be completely candid with the court, I don't know if there's been an offer made on the web portal or not. So I haven't really had a chance to discuss either case with the state. One is the weights are less than a gram apart. One is indicted as a first, one is indicted as a second. So that would be possibly an issue to be discussed among others, but I don't believe he has any felony history, but I'll have to just talk with the state and see if we can move it. We just need to set it, I guess, I hope one more reset.
Okay, there being no contested pretrial motions, court will set Mr. Ibarra for docket call. Court will set August 23rd. 1:30 if he's in jail, 9 a.m. if he's on bail.
And that was the 23rd, Your Honor?
Yes, I went ahead and set it at the same time I set Mr. Moorhead.
Thank you, Judge.
You're welcome. And Mr. Knoll, are you ready on Michael Marley by chance? Just a status.
I don't think he's in here.
He's not up yet, okay.
Hasn't been brought in yet. I believe she's gone to get a collection.
And Judge, this was the case where I left with state's attorney, I don't know, 2 inches of medical. And then I got sick and I haven't really had a chance to tell her the purpose of the medical, other than maybe in a quick 2 sentences. And I doubt seriously that she's had the time to do much of anything other than maybe a brief look at them. I'm not sure. I haven't had a chance to talk to her.
Okay. Deputy Phillips, if we could bring up Shayna Doby or Thomas Bailey. I have both. Mr. Stevens is with us in Zoom, and then Mr. Green is also logged in Zoom as well.
Can you give me the names one more time, Judge?
Yeah, it's on page 8 there. Shayna Doby
Uh-huh.
and Thomas Bailey.
Thomas Bailey. Yes, sir. Muted. Judge, we have Ms. Dovey here. Mr. Bailey, we've been asked to bring him to the room by himself, rather than that there may be an issue if he's in the room with others. So if it's okay with you, we'll hold off with him.
Okay, but you do have Ms. Doby?
Yes, sir.
All right, Ms. Doby, if you'll step up, Mr. Stevens, if you'll turn your camera on.
Your Honor, it won't let me turn my camera on. It says the host has disabled it.
Take off.
There it goes.
All right, this is cause number CR 22-130, CR 22-131, State versus Shayna Doby. We're set for pretrial. Mr. Stevens, any contested pretrial motions?
No, Your Honor, we not as of yet. We still have not received an offer from the prosecutor that I'm aware of. So I think we were waiting on that.
You've received your discovery?
Yes, we've got discovery.
Okay. All right. There being no contested pretrial motions filed, the court will set this for docket call. And court will expect an announcement on whether the case will be resolved by plea or by trial. And Mr. Stevens, if you have your calendar available, are you available on August 23rd?
Let me look, double check.
We can do August 9th, 11th, or 23rd.
What time on the 23rd?
Everything will be at 1:30 as the jail docket's always in the afternoon.
Okay, the 23rd is fine, Your Honor.
Okay. All right. Court sets Ms. Doby then for docket call on August 23rd at 1:30.
And Judge, just for the record, I emailed Mr. Linder the state's offer yesterday. So Mr. Stevens, if you will just communicate that to him to be on the lookout for that email and let me know if you didn't get it.
Oh, okay. Oh, he's in federal court today, so I'm sure he hadn't seen it yet. Thank you.
All right. If there's nothing further, then we'll be adjourned in this case.
Thank you.
You're welcome. All right, Ms. Doby, you can have a seat. All right, are you ready, Mr. Marley?
Well, Judge, I guess I'll repeat what I said earlier.
Well, no, I remember what you said. State, have you had time to review the records that Mr. Knowles provided? Do you want me to recall the case in a moment? State still there?
Yes, Judge. I'm sorry. I was checking on the medical records for Mr. Marley.
Well, I can recall it. So if you want to spend more time looking at it.
Well, Judge, I have not had time to review it, and it is quite voluminous. It was in Miss Melton's stack to be scanned in, and so we've located them, but they haven't been scanned in yet, so I haven't reviewed them yet.
Judge, if we could set him on the 23rd with the other two cases, maybe that'll give us time to talk about this case and the other.
All right.
Have a more meaningful conversation with Ms. Heisel on why I presented medical records.
So as far as our status goes on medical records, we've obtained all the medical records, no longer need status, set for docket call on August 23rd.
I believe so, Judge. Yes, we did get
Yes,
all
sir.
of that. Fine.
Okay. Mr. Marley is set for August 23rd at 1:30.
Thank you, Your Honor.
Thank you, Judge. I think that's all I have now. I'll be excused.
Yes, sir. I think that's it.
Thank you, Mr. Yes, sir.
What's your name?
We have anyone else that's ready?
We have Mr. Bailey here now, sir.
Okay, you bring in Mr. You said he's by himself, right?
Yes, sir.
Yes, sir.
Mr. Bailey, I'm bringing Mr. Green into the hearing. Give me just one moment. This is cause number CR 1688, CR 1689, State versus Thomas Logan Bailey, set for docket call. Mr. Green.
Judge, we would ask for another docket call. Since we were last in court while I was on vacation, I received notice that Mr. Bailey was charged or will be charged with some additional offenses. Spoke to Miss Curry this morning about that, and she's indicated that she's hoping that the cases are filed today so she can review them pretty quickly and get with me with a potential resolution.
State.
Your Honor, we would be in agreement. It does appear he has 3 new charges and they are all felony charges. So Ms. Curry just needs time to get those and review them to make an omnibus offer.
Okay, I'm gonna set for one more docket call because it appears that this case has been on the court's docket for a number of years, 6 years to be exact. So, and I know that Mr. Bailey has not been here the whole time. And so I'm gonna set it for one more docket call. We get it resolved. If y'all get it resolved, you get it resolved. If not, then I'm just gonna set it for trial. Okay.
Yes, sir.
All right. So are you available on August 9th or 11th?
Judge, that week I'm supposed to be in trial, set especially in Judge Evans' court in Palestine.
Let's look at September then. September 20th will be the next date.
September 20th.
Or the 22nd.
September 20th is fine, Judge.
20th.
Yes,
All
sir.
All right. Court sets Mr. Bailey for final docket call September 20th. That would be at 1:30.
Yes, sir.
Excuse me. Excuse me, Judge.
Mr. Bailey, I would say you need to talk with Mr. Green before you address the court. So it's probably in your best interest to do that. So
Can I
And we
can't
can,
see him right here?
no,
no,
Okay, all right,
you'll need to get with him outside of the court setting.
sir.
may I be excused, Your Honor?
Yes, thank you, Mr. Green.
Thank you.
Your Honor,
Yes, ma'am.
I see we have the 3 o'clock, which is, we're not ready for yet. We have 2 people that are waiting on Mr. Ashmore, and then the only other person that I see on our docket is a Canon Rackhow who doesn't have an attorney listed. Would you like me to bring him up?
Yes, ma'am. That'd be great.
Okay, give us just a couple minutes and we'll have him present for you.
All right, thanks. Deputy Phillips,
Yes, sir.
what was the issue with Mr. Bailey?
I'm not real sure exactly what it was. Deputy McLeish is the one that filled me in on that he would have to come up here alone. He wouldn't get along up with others. So,
Okay, all right, I'll message her and we'll find out.
thank you.
Thanks.
Your Honor.
All right, Mr. Raquel. This is cause number CR 2189 90 2025 96. Mr. Raquel, this hearing is on a motion. This hearing is on a motion to revoke. You're on probation in each one of your cases. The state's filed a motion to revoke your community supervision. Are you going to hire an attorney to represent you? We've not received any requests for court-appointed counsel. You're going to represent yourself. What is your plan on how to dispose of your cases?
I do plan on to hire an attorney. I misread the paperwork and wasn't aware.
So what have you done to hire an attorney so far?
Well, I have the paperwork to fill out for a court appointed, but I just hadn't filled it out yet.
Well, I thought you just told me you're going to hire an attorney.
Well, yes, sir.
Well, are you going to hire an attorney, or are you going to ask me to appoint you an attorney? Those are not the same thing. Hiring an attorney means you get on the phone, or your family gets on the phone and they hire an attorney. They pay a retainer, they pay whatever fees are required, and the attorney comes in and represents you. Or if you want a court-appointed attorney, then the court appoints you an attorney who has signed up with the court to provide indigent legal defense, and you don't get to select who that is. The court selects who that is, and you may or may not be required to pay them back.
Yes, sir.
So you understand the difference?
Yes, sir.
Okay, so are you going to hire your own attorney, or are you going to ask the court to appoint you one?
But I'd like to ask for y'all to appoint me one.
Okay, so when are you going to send that paperwork in? Because we've been waiting for it. We've been looking for it. Your family's been calling. We've been telling them, you haven't filled out any paperwork. You've just been sitting in the jail. Do you plan on just sitting there forever?
Well, no, sir, I wasn't aware. I didn't know how to do all that.
You didn't know how to fill out court-appointed paperwork?
Well, I know how to, I just didn't know that I was needed to.
Well, did you think we were just going to automatically appoint you one?
No, sir. I
I mean,
didn't know.
who was your attorney before you got on probation?
Jonathan Manning.
Okay, was he court-appointed or was he retained? Court-appointed. So you've already been through this process. So what do you mean you don't know?
And I didn't know I had to refile for one.
Well, you do. So you need to fill out your paperwork. You need to get it turned in. And then we'll determine if you're indigent. If so, then we'll appoint you someone. If not, I'll let you know.
Yes, sir.
Okay, so you need to go. I'm going to have my indigent defense coordinator send the paperwork over there. I need you to fill it out. Otherwise, we're just going to come back every 30 days. And if you want to sit in jail the rest of your life, I guess you can do that. All right. So get the paperwork filled out so I can do something with it.
Yes, sir.
All right. So I'm going to call you up here in just a little bit. I'm going to have them send the paperwork over. You're going to fill it out today, and we're going to deal with this issue today.
Thank you.
All right. You may have a seat.
Your Honor, at this time, all we have is Mr. Ashmore's. We have not seen Mr. Ashmore. And then a 3 o'clock Zoom meeting.
State, have you had any contact with Mr. Ashmore?
Judge, I spoke with Mr. Ashmore yesterday. He stated he was in mediation this morning. He was hoping to be able to appear this afternoon. That's what I've heard. I haven't heard anything today about whether he was going to be able to be here or not.
All right. Is Mr. Manning still there?
No, sir.
All right. There was another one on our docket that he didn't announce on, Zachary Bird. I have that he was verified in Rockwall County Jail. I believe that's still to be the case. So we'll just reset that for status on August 11th.
Your Honor, Mr. Manning is returning. He took some papers with him and he is going to be bringing them back. Would you like us to let you know when he's returned?
That, or you can just let him know we've reset, because I don't think he has any more live clients there in the jail. So you just let him know we've reset Mr. Bird till August 11th for status, unless he has an announcement or something that he can tell me more about.
Yes, sir.
All right, court will stand in recess until Mr. Ashmore arrives and.
Your Honor, Mr. Ashmore is here. He's coming into the building now.
Okay, we'll stand in recess until he's ready to announce or until Mr. Rackow has completed his paperwork.
Yes, sir.
Sir.
Your Honor,
Yes, sir.
Mr. Ashmore's ready.
All right, be just a few minutes.
Yes.
It's only 103.
I didn't think it was that bad.
It's not that bad. It's really fun.
93.
It's cloudy today.
93.
It's probably 93.
Yeah, it's been cloudy all day, but it hasn't rained at all. It's all north of.
But it's in the vicinity and it's not 110 degrees outside. The sun is.
Need the rain.
microwaving everything. Today's a good day. Tomorrow the sun will be back. It will be microwaved.
It says rain tomorrow.
What? Are you looking,
Lord, send the rain.
are you looking at Texas? Not like
You know what? It's
Tennessee
like been
or-
blowing like a
Texas.
banshee in Amarillo, which gets like 3 inches of rain a year, and we're dry as unbuttered popcorn. Crazy.
Amarillo's always windy though. They say the only thing between Amarillo and the Gulf is barbed wire fence.
And a feedlot that blows right across the highway. Especially when you're wearing a no shield on a motorcycle.
you ask the farmers out there, it smells like money. I think it smells like what you get on your boots when you walk in the pasture. It's a good place to drive. It's a good place to be from.
So actually, at 5 o'clock tomorrow, there's a 43% chance of rain.
What?
Yeah. And 93.
No, it's not.
What was it, 109 yesterday?
Yeah, and and the wind was blowing, like standing in front of a giant hairdryer.
It's exactly what it's like.
City folk keep tabs and stuff like this, but all these poor farmers out here, like the county's trying to burn itself down.
Yeah, I know. I mean, I've been seeing the smoke as I drive in and
Yeah,
out.
that's it, the smoke signal.
Well, and Hoffman's on.
We'll come to order. Let's bring this court to order.
Is this wait?
All right, I just want to make sure my gavel was working. I haven't used it in a while, so. Good afternoon, Mr. Ashmore.
Good afternoon, John. I think you used it the last time you used it was one of my clients.
Oh, that wasn't when I held you in contempt and you went to jail that day, or?
I've got my bail bond right here, ready to go. And I got my motion to recuse, ready to e-file.
Good one. Nice. Yeah. Those are handy. Those are A and B, exhibit A and exhibit B. Who are you ready on?
Let's do Mr. Shackelford because it's just a quick reset. Come on,
Okay.
buddy.
John Wayne Shackelford, CR 22-117.
Judge, we've reached a plea agreement with the state, which we want to accept. The terms of that agreement are 1244A, time served, the charge. Mr. Shackelford served a sufficient time in jail, and the state and Mr. Shackelford and I have agreed on this proposal. We don't have time to complete that paperwork today. We're just asking for a reset. We just set it out at the next available docket, but we're trying to get back here on a short timetable, kind of like we did today, to resolve this matter for Mr. Shackelford, Your Honor.
Okay. Is he gonna be paying fines and court costs or reimbursement prior to or at the time of the plea? Reason I ask is I show that he's had 3 other misdemeanor cases and he's not done what he's supposed to on those. He owes over $3,000. Doesn't look like he's paid anything.
I was not aware of that, Judge.
Well, we're gonna reset it, and that's probably something you should talk to him about. I'm not sure if I'll accept the plea based on his past performance.
Yes, Judge.
So let's reset, and you can work that out with him. What date were you thinking, Mr. Ashmore?
Trying to get the calendar to work. Just a second, Judge. Judge, can we just set it on the 23rd? And if we can get back before then, I'll do that. 23rd of August. I know that's a day the court has available and I think has room.
Yeah, let me double check. I think we were, see if I exceeded my capacity for that day yet. Yeah, that will a little over 7, right about 70. So, yeah, we'll go ahead and set Mr. Shackelford on 8/23. So, Mr. Ashmore, what I would expect to see is some kind of good faith payment that's going to tell me that he's going to actually do what he says he's going to do, because right now, I don't think he will. So
I understand, Judge.
that's what's going to be in the back of my mind when the plea's being read. And if it's a 1244A time served, I may not accept that.
Understood, Judge. No, okay. Judge, we're ready on Jesse Wagner Henry.
All right, Mr. Henry. CR 2168, CR 2341.
Judge, we are here on a plea. The terms of that plea agreement are plea of guilty to the lesser included offense of assault, causes bodily injury, family member, punishment 236 days in the county jail, credit for time served, fine of $1,000, includes 100 family violence fine, 1245 the bail jumping, court costs of $270, reimbursement fees of $1,015. Already explained to Mr. Henry about his duty to come meet with the county and resolve his financial obligations. We're asking the court to accept that plea. Thank you.
So I have on my, there was a motion to withdraw an attorney status. Is that something we need to take up?
That's your.
You're saying no, Mr. Henry, so you're telling me at this time you're pleased with Mr. Ashmore's representation? You don't want me to hear you out on your motion?
No, no, sir. I want to stand by my lawyer.
All right, and Mr. Ashmore, what did you say was going to be the disposition on the bail jumping and failure to appear?
1245, Your Honor.
Give me just a second to review this case.
Yes, Judge.
Mr. Ashmore, you address the concern I have, the time served essence of this plea with Mr. Henry being ordered to pay out his fines and court costs. I have concerns if he was indicted for failing to appear and not showing back up to the court. How can the court trust that he's going to pay the court costs and reimbursements to the Van Zandt County taxpayers? Tell me why I should not have concern about that and I should accept this plea.
Judge, the the bail jumping matter was an error because of COVID, some confusion about the court date. And, you know, prior to that, Jesse had appeared at every single court hearing. He never missed a setting.
I did have, I use a piece of shit.
Objection sidebar, I guess. Anyway, Your Honor, Jesse never missed a hearing until COVID. And after that, yeah, you know, that we were in the middle of plea negotiations with the state at that time. Some confusion about, I don't remember for exactly, because it's been about 2 years, whether that was a video appearance that he didn't get that paperwork, or an appearance at the courthouse. Got it. Okay. So Mr. Henry just reminded me that he doesn't have electricity on his property during the hottest month, which I believe he missed an August, or maybe it was a July, but the correspondence and the communication that came from the court about his setting, he just missed it. It wasn't intentional. It wasn't a disregard to the court's process. And again, it was in the middle of that pandemic. I think the court could be assured that Mr. Henry will square this away. He wants to go home. And I've explained to him he needs to get up to the courthouse, get on a payment plan to resolve these fines and court costs.
All right, Mr. Henry, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes, sir.
All right, let me put you down. Your name is Jesse Wagner Henry, is that correct?
That's correct.
And Mr. Henry, are you a United States citizen?
Yes,
Do you read, write, and speak English?
yes,
Have you ever been diagnosed with any type of mental condition?
no,
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
yes,
Feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
that's correct.
Is there anything about this paperwork that you've read and signed today that you do not understand?
Negative.
Mr. Ashmore, do you believe that Mr. Henry is competent today? You've explained to him his legal rights?
Yes, Judge.
All right, Mr. Henry, you are charged. You were charged by indictment with. Get to it. You were charged by indictment with continuous violence against the family, a third-degree felony, which carries a range of punishment of 2 to 10. However, the plea agreement in this case appears to be that of a lesser included offense of assault causes bodily injury, family member, a class A misdemeanor, which carries a range of punishment up to a maximum 365 days in the county jail and a fine not to exceed $4,000. I see the plea agreement in this case would fit within that range of punishment. If you were convicted pursuant to the plea agreement and sentenced to the 236 days in the county jail with credit for time served, in addition to a $1,000 fine plus court costs, reimbursement fees, and the fine. And you would be awarded 236 days credit towards your sentence. Is that your understanding of the plea agreement, Mr. Henry?
Yes, it is.
All right, understanding the plea agreement and the range of punishment, do you still wish to go forward in this case?
Yes, sir.
All right, court will ask you at this time, Mr. Henry, how do you plead to assault causes bodily injury of a family member?
No contest.
Is that the agreement with the state? No contest?
Judge, that's,
Guilty.
I'm sorry, state, go ahead and answer.
that was not discussed. I believe Mr. Ashmore, they were having a discussion.
Mr. Henry is okay with allocuting to the offense.
Okay, so Mr. Henry, I'll ask you again, how do you plead to that offense?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
I guess we need a minute. Excuse us just a moment.
All right, have a seat. Sorry, Deputy McLeish, that wasn't for you. That wasn't for you. That was for the Henderson County Jail. All right, this is cause number CR 21-339 and CR 21-340, State of Texas versus Tad Michael Russell. Mr. Schmidt, are you ready, sir? You may be about to join us. There he is. All right, Mr. Schmidt, if you'll unmute, are you ready to proceed?
I am, Your Honor.
All right, this is cause, as I said before, this is cause number CR 21-340-339, State versus Tad Michael Russell. Appears to me that Mr. Russell wants to enter a plea before the court today. Is that correct, Mr. Schmidt?
It is, Your Honor.
All right, Mr. Russell, if you'll raise your right hand, I'm going to place you under oath. Your screen is gone. Hang on, put your hand down for just a second, Mr. Russell. Court reporter's having some technical issues. Sort of, you good? All right, let's try it again. Raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. Your name is Tad Michael Russell, is that right?
Yes.
Mr. Russell, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
PTSD, depression, and anxiety.
Are you currently on medication for those or undergoing treatment?
Yes.
Do you feel like you have a rational understanding of the proceedings as they are occurring here today?
Yes, sir.
In this case, you're represented by your attorney, Mr. Brian Schmidt. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered?
Yes.
And your signature as it appears in these documents, is this your true and correct signature? And did you
Yes,
only sign once you were confident you knew what you were signing?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent today?
I do, Your Honor.
And have you explained to him his legal rights as they pertain to this case?
I have, Your Honor.
All right, Mr. Russell, you are charged by indictment with a third-degree felony offense of unlawful possession of firearm by a felon, which does carry a range of punishment of not less than 2 years or more than 10 years in prison, and a fine not to exceed $10,000. I see the plea agreement in this case is that you would plead guilty to that charge. The state's recommendation is that punishment be assessed at 10 years confinement and a $2,000 fine, plus court costs and reimbursement fees, with you receiving 138 days credit towards your sentence for time that you have spent in jail on this cause. Mr. Russell, is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve today, is that right?
Yes, sir.
All right, Mr. Russell, how do you plead to unlawful possession of firearm by a felon?
Guilty.
Are you pleading guilty to this crime because you are guilty of committing this crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state would like to address that it has tendered a motion to dismiss on the aggravated assault charge. We would like you to take that up at this time, and then nothing further from the state.
That's correct, Your Honor.
All right, court finds that the state has tendered a motion to dismiss in CR 21-339. Court will grant the state's motion as filed. Anything further from the defense, Mr. Schmidt?
No, Your Honor.
All right, the court's going to review the evidence briefly. All right, court's reviewed the evidence, and I do find sufficient evidence to convict Mr. Russell of this offense. Court will follow the plea agreement in this case. Court convicts Tad Michael Russell of unlawful possession of firearm by felon. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,000 fine, $290 court cost, $85 reimbursement fees, and the court awards Mr. Russell 138 days credit towards his sentence for the time that he has spent in jail. Court has also signed the order of dismissal and cause number CR 21339. All right, Mr. Russell, before I remand you back over to the sheriff to carry out the terms and conditions of the sentence, I'm going to tell you that I was very upset by the comment that you made in my courtroom just a few moments ago. And you know what I'm talking about, don't you?
Sorry about that.
Yeah, very
We
disrespectful.
didn't realize that we were on.
I don't care if you realized you were on or not. Still very disrespectful, inappropriate.
Yes, sir. I'm sorry about that. I apologize.
I really considered holding you in contempt of court because it was disrupting my proceeding.
I'm sorry about that. I apologize. I didn't realize that I was already on.
Be thankful to Mr. Schmidt who offered me an explanation off the record. But I would think twice before I opened my mouth if I didn't know who was listening, when they were listening, and who's recording, who's broadcasting this.
Yes, sir. I apologize.
All right, Mr. Russell, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to remand you to the custody of the sheriff at this time.
Thank you.
Anything further, Mr. Schmidt?
No, that's all I have. Might be excused, Your Honor.
Yes, thank you, Mr. Schmidt.
Thank you.
There we go. All right, Your Honor, Mr. Ashmore's ready now.
All right, Mr. Henry. You go. All right, so I believe that in the plea, the court had asked Mr. Henry how he pled to this offense. Mr. Henry indicated after some discussion that he would plead guilty to this crime. I asked him if he was pleading guilty to this crime because he was guilty for no other reason. And I believe at that time there was a request by Mr. Ashmore to speak with his client. Mr. Ashmore, have you and Mr. Henry had enough time to finish your discussion?
We have, Your Honor, and we're ready to proceed, and Jesse's ready to allocate to the offense. Obviously, this is a disputed matter, which is the reason why it's taken over 2 years to resolve it. So, but we're ready to proceed, Your Honor.
All right, so Mr. Henry, I'm going to re-ask you, how do you plead to assault causes bodily injury of a family member?
Guilty.
And are you pleading guilty because you are guilty of committing that crime?
Yes.
All right, court will accept the defendant's plea of guilt at this time. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, the state is in compliance with victim notification. The alleged victim of the victim of these crimes, Ms. Broomley, is uncooperative with our prosecution. That is the basis of this reduction that we have offered and agreed to Mr. Henry. She has requested on multiple occasions to fill out an affidavit of non-prosecution, but has never actually made that. But we have been in contact. She does not wish to cooperate further with our prosecution. And with that, we would rest it close.
Thank you, Mr. Gordon. Anything further from Mr. Ashmore?
No, that's exactly what we understood the situation to be too, and how we reached this resolution.
Okay, the court's going to review the evidence. All right, court has reviewed the evidence. I do find sufficient evidence to convict Mr. Henry of this offense. Court will follow the plea agreement in this case. Court hereby convicts Jesse Wagner Henry of assault, causes bodily injury of a family member, family violence. The court assesses his punishment, Class A misdemeanor, to 236 days in the county jail. Court will award him credit for the time served of 236 days. Court orders him to pay a $1,000 fine, $270 court costs, and reimbursement fees of $1,015. Mr. Henry, whenever you are released from the Van Zandt County Justice Center, I'm going to order you to report immediately to the Van Zandt County Courthouse and make arrangements to begin your payments on the fines and fees that you owe the county. Mr. Henry, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'll have you step over to be fingerprinted with the bailiff. The court is also signing the dismissal in CR 2341, the bail jumping case.
Judge, I need just a moment to visit with Mr. Myers. We got his paperwork. We're
Yes, sir.
ready in just a second.
Yes, sir. Yes, it's going to be a plea that we're going to do. It's actually set on the jury docket.
Okay, so.
Week after next. Yeah, it's an add-on, CR 2299, CR 2299, Philip 1L, Patrick Myers, MEYERS. It is assault, family violence, previous conviction.
You just show up. Go to your house.
Third floor. Yeah, or tomorrow morning first thing. Right, okay.
All right, Your Honor, we're ready.
All right, Mr. Myers, if you'll raise your right hand, sir, this is cause number CR 2299, State versus Philip Patrick Ray Myers. Mr. Myers, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, you put your hand down. Your name is Philip Patrick Ray Myers, is that correct?
Yes, sir.
And Mr. Myers, are you a United States citizen?
Yes, sir, I am, Your Honor.
And do you read, write, and speak English?
Yes, sir, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, sir, Your Honor.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir, Your Honor, I am.
And do you feel like you've had enough time to discuss your case with Mr. Ashmore and have all of your legal questions answered?
Yes, sir, Your Honor.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir, Your Honor.
And where you signed in the paperwork, is that your true and correct signature? And did you only sign it once you were satisfied you understood what you were signing?
Yes, sir, Your Honor.
Mr. Ashmore, do you believe your client to be competent today?
Yes, Judge.
And you've explained to him his legal rights?
Yes, Your Honor.
All right, Mr. Myers. You were originally indicted with a third-degree felony offense of assault of a family or household member with previous convictions. That carries a range of punishment of 2 years in prison up to a maximum of 10. I see here, though, that the plea agreement in your case is that you would be pleading guilty to a lesser included offense, a Class A misdemeanor, assault causes bodily injury, family member, with a punishment recommendation of 1 year in the county jail, with you receiving credit for all 365 days being time served, plus a $1,500 fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement, Mr. Myers?
Yes, sir.
You understanding the range of punishment in the plea agreement, you still wish to go forward?
Yes, sir, Your Honor.
All right, Mr. Myers, how do you plead to assault causes bodily injury of a family member, a Class A misdemeanor?
Guilty, Your Honor.
You're pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir, Your Honor.
All right, court accepts the defendant's plea of guilt. Mr. Ashmore, any objection to state's evidence?
No, Your Honor.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that the state is in compliance with victim notification.
Thank you, Ms. Heisel. Anything further, Mr. Ashmore?
No, Your Honor. Thank you.
All right, court's going to review the evidence. All right, court's reviewed the evidence. I find sufficient evidence to convict Mr. Myers. Court will follow the plea agreement in this case. Court convicts Philip Patrick Ray Myers of assault causes bodily injury, family member. Court assesses his punishment at 365 days, 1 year in the county jail. Court will award him 365 days credit towards his sentence for time served. Court orders him to pay a fine of $1,500, court costs of $270, and orders him to reimburse Van Zandt County $830. Mr. Myers, upon being released from the Van Zandt County Courthouse or from the Van Zandt County Justice Center, I'm going to order you to report to the Van Zandt County Courthouse so you can make payment on your fines, court costs, reimbursement fees. If you are unable to pay all of those up at once, then you're ordered to make a payment plan and get those things discharged. And your failure to do so will result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir, Your Honor.
All right, Mr. Myers, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence and have you step over to the deputy to be fingerprinted.
Yes, sir, Your Honor. Thank you.
You're welcome.
Thank you, sir.
Put me in, coach. What you got? I'm just kidding. I think that's
No,
it.
no, 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 no. You said, what do I got? Let me look. Look, I bet I got something juicy. Let's see, we've got one defendant who's on their 8th attorney. He could be 9.
Judge, do we ever figure out what Mr. Rackow is doing? He was the one who needed court appointed.
Yes, I believe that Mr. Manning has been appointed. He's
Okay.
been deemed indigent, and so I'm gonna just send notice to him that we're gonna set him for 2 hearings. We're gonna set him for August 11th on motion to revoke, and then we're gonna set him for contested on 8/25.
Thank you, Judge.
And I'll have Ms. Tabraham send that to Mr. Manning. So we don't need to bring Mr. Rackow. Is Mr. Rackow in the room?
Yes, sir, he is.
Oh, yes. Well, Mr. Rackow, come on up then. All right, Mr. Rackow, the court's going to appoint Mr. Manning to represent you again. And I'm going to reset your cases for August 11th. That's another opportunity for you to announce if you're going to reach an agreement, resolve your cases. If there's no agreement reached on August 11th, then we will have a contested hearing on August 25th, and the court will hear the evidence of the state. Okay, so Mr. Manning will get notice of the appointment today, and I'm sure within a few days he'll make contact with you. Okay.
Thank you, Your Honor.
Deputy McLeish, is there anything else that you're aware of that needs addressing?
That is all that's on our docket.
That is all that's on our docket.
Deputy McLeish, I love what you've done with your hair.
Yes. Looks just as good as yours.
You know what? I'm not even gonna get there. I'll be there 2.5 years.
I saw you getting in the elevator the other day. You're not far from.
Hey, just because you're
Ooh,
leaving.
that's on YouTube now.
Hey, just because you're leaving doesn't mean you start throwing haymakers on the way out.
Get out of here.
Yeah, Casey, you better go. Better go. Make sure he hasn't observed anything about you. All right, then that's going to resume today's docket. I appreciate everyone's help. Tell everyone in the detention center over there, Deputy McLeish, I do appreciate their help. If that everyone is you, then thank you. Thank you, Deputy Phillips.
Yes, sir.
Be adjourned.